This is the ruling. High Court Criminal Miscellaneous Application number 121 of 2022, arising out of Uganda Road, criminal case number 622 of 2022, Dr. Kizza Besigye and another versus Uganda. Before Honorable Justice Asime Tadeo, this is the ruling. The applicants were charged with the offense of incitement to violence contrary to Section 51, subsection 1, paragraph B of the Penal Code Act. They applied for bail in the Uganda Road Court, which was rejected by the magistrate grade 1. Being satisfied with the decision, the applicants filed a fresh application for bail in this court by way of notice of motion under Article 23(6)(a) and 28(3)(a) of the Constitution and Section 75(4) and Section 77(3) of the Magistrates Courts Act. At the hearing, the applicants were represented by Counsel Analyst Karibara, Samuel Muizi, Abdallah Chiwanuka, and Ivan Bowe, while the respondent was represented by Mr. Wanamama and Njuchi Mariam, state attorneys from the office of the DPP. The applicants filed written submissions which were adopted on record and proceeded to present sureties which were not objected to and hence substantial. In reply to the application, the Land State Attorney raised a preliminary objection relating to the jurisdiction of this court, which I will deal with before going to the merits of this application. In support of the above objection, the Land State Attorney relied on the affidavits of Nama Koyekaseri, an Assistant Director of Public Prosecution, and Kizza Ann, a Chief State Attorney. He also cited Section 75(2), 3, and 4 of the Magistrates Court Act, arguing that this application is prematurely before this court, as the law provides that it should have been handled by the Chief Magistrate before coming to this court. In response to the objection, counsel for the applicant cited Sections 75(4) and Section 77(3) of the Magistrates Court Act, arguing that the High Court is clothed with unlimited jurisdiction to entertain matters of this nature. In his view, once the Magistrates Court rejects to grant bail, both the Chief Magistrate and the High Court have jurisdiction to entertain a fresh application for bail, and that the choice on where to file the fresh application is the choice to be made by the applicant. Resolution. I have considered the oral submissions for and against the objection and the law cited by both counsel in relation to the jurisdiction of the High Court in grant of bail in the circumstances. There is no doubt that both courts have powers to grant and choose the person. However, the circumstances differ. Ordinarily, bail is non-capital. Bail in non-capital cases is handled by the Magistrates Court. The Magistrates Court Act is very I quote, a magistrate's court before which a person appears or is brought charged with an offense other than the offenses specified in subsection 2 may, at any stage in the proceedings, release the person on bail on taking from him or her a recognizance consisting of a bond with or without surety for such an amount as is reasonable in the circumstances of the case, to appear before the court on such a date and at such a time as is named in the bond. The section continues under subsection 2. The offences excluded from the grant of bail under subsection 1 are as follows. A. An offence tried only by the High Court. B. The offence of terrorism and any other offence punishable by more than 10 years imprisonment under the Anti-Terrorism Act. Paragraph B, substituted by paragraph 3A of Act 7 of 2007. C, an offence under the Penal Code Act relating to an offence under the Penal Code Act relating to cattle rustling. B, offences under the Firearms Act punishable by more than 10 years imprisonment. D, substituted by section 3B of Act 7 of 27. E, paragraph E repealed. Those paragraphs were repealed. Then G, embezzlement contrary to section 268 of the Penal Code Act. And H, causing financial loss contrary to section 269 of the Penal Code Act. I, corruption contrary to section 2 of the Prevention of Corruption Act. J, bribery of a member of public body contrary to section 5 of the Prevention of Corruption Act. And K, any other offence in respect of which a magistrate's court has no jurisdiction to grant bail. The court continues under paragraph 3, subsection 3. A chief magistrate may, in any other case other than in the case of an offence specified in some section 2, direct that any person whom bail has been refused by a lower court within the area of his or her jurisdiction be released on bail, or that the amount required on any bail bond be reduced. Subparagraph 4. The High Court may, in any case where an accused person is appearing before a magistrate court, or where the case is not one mentioned in subsection 2, direct that any person whom bail has been refused by the magistrate's court be released on bail, or that the amount required for any bail bond be reduced, and where the case is one mentioned in subsection 2, direct that the accused be released on bail. From the reading of the above provision of the law, I agree with counsel for the applicant that section 75(4) closed this court with jurisdiction to entertain an application for bail where the same has been refused by the magistrate's court. However, section 75(4) cited above cannot be read in isolation of section 75(1), 2, and 3, which completes the administrative hierarchy of the magistrate's courts while dealing with bail matters before a fresh application can be filed in the High Court. I am also arrived to section 77(3), as was cited by the applicant's counsel. I shall quote it in verbatim. Where bail is not granted under section 75, the court shall record the reasons why bail was not granted and inform the applicant of his or her right to apply for bail to the High Court or to a chief magistrate as the circumstances may require. In interpretation of the above provision of the law, my attention is drawn to the last phrase, as the circumstances may require. In my view, the above section has to be read together with section 75 for one to understand the kind of circumstances referred to in section 77(3) above. To be clear, the circumstances are that once bail is refused by a grade 1 magistrate, a new application is filed before the chief magistrate. And once bail is refused by the chief magistrate, then a fresh application is filed before the High Court. In my opinion, Section 77(3) does not create a concurrent jurisdiction between the High Court and the Chief Magistrate's Court, as counsel for the applicant wants this court to believe, but rather highlights on which court one can file a fresh application depending on which court denied the earlier bail. The rules of procedure in the books of law are intentional to avoid unnecessary applications, stroke matters, and to avoid opening floodgates of unnecessary matters moving in the High Court before exhausting the available remedies in the lower courts. Defying such procedures would be to interfere with the judicial processes of the lower courts and inviting premature causes in the High Court and creating unnecessary backlog. My understanding of Section 75 and 77 is that all options in the Magistrate's Court must be exhausted in non-capital cases before filing in this court. Therefore, the applicants should have filed this application before the Chief Magistrate before coming to the High Court. There is also an option of returning to a Grade 1 magistrate who is trying the case. It is the finding of this court that this application was brought prematurely before this court, and therefore there is no need to go to its merits. For the above reasons, this application is hereby dismissed. The applicants are free to file a fresh application to the Chief Magistrate's Court if they so desire. Before I take leave of this court, I wish to point out that where the preliminary points of law are envisaged by any party, the same ought to be raised at the commencement of the trial. The land state attorney in this matter failed to do so, leaving the courts to go through the whole trial, wasting court's time. I hope this in the future will be done correctly. Signed by Honorable Justice Sime Sadeo, the Judge of the High Court, dated 30th June 2022. So to the applicants, I hope you have taken the reasoning of the judge. Yes. You either go and file it for the Chief Magistrate, or you go back to the
What's the problem with you? Even
I have
NDA steakhouse.